Patrick Brown, owner and partner at McLeish Orlando, a recognized leader in personal injury law. Patrick Brown has been practicing for over 20 years and has dedicated his career to helping those who suffer serious and catastrophic personal injuries. He also helps those families who have lost a loved one due to the fault of another. He has cases throughout Ontario and is the leader in the area of personal injury law. Patrick, welcome. Please tell us about the Moore decision. What are the salient facts of that case?
Yeah, the Moore decision came out of the Court of Appeal just this year. It's a significant decision involving a case of wrongful death. To give context to the decision, Alicia was a young lady, 24 years old. She actually rented an apartment, a basement apartment, from a landlord. In that particular apartment, the windows were barred, and as well, there were two exits, of which only one was available to Alicia. And a horrific fire broke out, and essentially Alicia was trapped. She suffered really severe and significant burns across her body. She was taken to the hospital where she was treated, but unfortunately, life support had to be withdrawn from her, and she passed away. Following that, her mom and dad brought a wrongful death lawsuit against the defendant landlord. That was brought by Mike Smitchuk in his office, and it was also in front of a jury. The jury heard evidence, and at the end of the case, made various awards. Part of the awards were for some future care costs for mom and dad. But the significant part that I think I want to talk about, and especially what eventually gets appealed, were the awards to mom and dad for mental distress and the awards to mom and dad for loss of care, guidance, and companionship. In that particular case, the jury came back and gave mom $250,000 for mental distress. They also gave dad $250,000 for mental distress. They also awarded mom $250,000 for the loss of care, guidance, and companionship, and they gave dad the same $250,000 award for loss of care, guidance, and companionship. After the jury had rendered that verdict, the defendant landlord appealed it to the Court of Appeal, and he appealed it on the Court of Appeal on different bases, but one of the main ones was, hey, this is too high. You're not following the Toe decision that was, and the Toe decision, just so you know, it was a Court of Appeal decision where Mr. Toe back in 1992 was a 14-year-old boy that was injured when a European handball had crushed his skull during gym class. And that case went to trial, and eventually it went all the way to the Court of Appeal, and they upheld a $100,000 award for the parents of that 14-year-old boy. And since that time, based on references in that case, many people said, well, hey, that's like a cap that's been given to the loss of a child to a parent for loss of care, guidance, and companionship. You really shouldn't be able to go over that cap. And they've made that argument for years. And in this particular case, they made the same argument. Hey, you've gone from 100 to 250,000 in this award. That's too high, Court of Appeal. That's contrary to Toe. And the Court of Appeal said, well, wait a second. Firstly, the Toe decision at 100,000 in 1992 indexed to 2013 when Alicia was killed would really be 150,000. So we've really gone from 150,000 to 250,000. That's about 66%. Number two, since Toe, there's been a decision called Young versus Bella, which is a Supreme Court of Canada decision. And in that particular case, the Supreme Court said, hey, Court of Appeal, don't overturn jury verdicts on non-pecuniary damages unless that shocks the conscience of the court. And so when they took a look at this decision and the movement up to 250 for Alicia's parents, they said, we don't think that shocks the conscience of the court. we don't. And as a result, we're not overturning it. And that decision is going to be remaining. And I think that is a significant finding. I think it sends a message to everyone that TOE was never a cap on damages for wrongful death. It was the high end, but it's not a cap. And certainly moving up 66% does not shock the conscience of this court, the Court of Appeal, on that award of $250,000. And so they allowed it to stand. And I think that was the one area that should be paid particular attention, but by anybody practicing personal injury, whether it be on the plaintiff side or the defense side. I think the other takeaway from that case is they also awarded $250,000 to each parent for mental distress. And obviously it was based in part that these parents saw their daughter, and that was their only daughter, meaning she was a single child, burned, badly burned, and then eventually a few days later are there when life support has to be withdrawn. And that in and of itself, in addition to the psychological expert evidence that Mr. Smitchuk and trial counsel called, was enough to support that type of award. And they felt that that was not going to be overturned as well. So when dealing with wrongful death cases moving forward, I think everybody has to pay attention to this decision and what they said in regards to this type of loss, and what the Court of Appeal may do in the future when juries do give awards of this nature.
And what are the most significant implications of these decisions going forward?
Yeah, and it's going to have I think, a pretty big significance. I mean, TOE happened back in 1992. Obviously, we've moved now to here. We've seen an increase, or at least an amount that's upheld by the Court of Appeal for loss of care, guidance, and companionship. We know that juries do have a tendency to feel that the loss of life and the loss of care, guidance, and companionship should be at times awarded more than what the TOE decision was. And I think we know now, too, that the Court of Appeal isn't necessarily going to interfere, at least to this degree, on those types of awards. And many people will say, well, this only applies to the loss of a child. Well, no, this is going to have applications, whether it be a loss of a parent, a loss of a sibling, a loss of a grandchild, or a loss of a grandparent. It's going to have the same implications as it did in Alicia's case and her parents. So I think the markers are going to be moved, and they're going to be moved on all these types of awards. And no longer should counsel simply think that TOE is a cap, or that things should not be awarded above TOE, and that our Court of Appeal is going to be receptive when a jury does give these awards. So yeah, I think it has significant implications, and I think it will make a difference out there on a lot of different levels. People may argue as well that, wow, well, those facts are very unusual in the sense that Alicia and her death and her parents' loss are an unusual set of circumstances that won't arise a lot. I think people should understand that in this particular case, she was an adult. She was 24 years old. At the time, she wasn't living with her mom and dad. Number three, her mom and dad actually had been divorced. And number four, she was an only child. So, I mean, those are some of the facts you can glean from the case. But are those an unusual set of facts for the loss of an adult daughter? I don't think so. I don't think so. I think it's what really is happening is a recognition that loss of life, and then they actually recite a passage in the case that you can read from the Mason Peters Award of how we should value that. And I think this is a reflection of how juries see it. I think it's a reflection of what the Court of Appeal is going to do when awards like this are granted by them. So it's a game changer. And hats off to trial counsel Mike Smitchuk and as well appeal counsel Chris Morrison on this.
And please tell us about Anon versus Simplicity Air. What was that decision about?
It's a very interesting decision by the Court of Appeal this year. A little bit different than the Moore decision in the sense that this was a case, and it's got an odd set of facts, but it was a gentleman who was at work. His name was Daniel, and he showed up at work. One of his coworkers kind of said, "Hey, Daniel, why don't you climb that chain hoist," which was inside the work area. And Daniel decided, "Okay, I'll take you up on it." And he climbs up this chain hoist, and he climbs up it, and then on the way down, he catches a hook, and it actually tears open his scrotum, and he has a pretty significant injury in his genital area. So from there, Daniel actually sues his employer, and that goes to a jury trial. And at the end of that particular jury trial, Daniel is awarded an amount of money for loss of income, an amount of money for pain and suffering. And he's also awarded $75,000 for punitive damages. The $75,000 punitive damage was kind of connected to the way these supervisors of Daniel's reacted to him once he had the injury. So they actually, from the decision, laughed at him. They weren't calling an ambulance for him. And they even tried to suggest, "Wow, Daniel, say that you got hurt at home." And so their conduct was considered, obviously, by this jury as egregious, and they awarded $75,000 to Daniel for punitive damages. Now, what's really interesting is they appeal this case to the Court of Appeal, and they appealed it on the basis of different areas. But number one, firstly, the punitive damages is too much. And the court says, no, it's not something that we're prepared to overturn. There was evidence called that supported that award. And then unless we feel that it's outside of what I've already talked about, being so inordinately high that it exceeds the rationale for punitive damages, we're not going to touch it. And they didn't. The other important thing is the defendant employer also argued, well, wait a sec, we got sued as an employer, we're a corporate entity, but the actual supervisors who laughed at him and didn't call the ambulance and told him that, hey, you should say that it happened at home. Well, that's not us. Those are individuals, and we shouldn't be responsible or be punished for the conduct of these individuals. And the court said, no, you were the employer. These individuals, even though they weren't sued, were in the course of their employment. And in fact, you're vicariously liable for their conduct. And as a result, they upheld the punitive damage award against the employer. The only other added thing, too, is they also said it was part of the culture of the employment relation, of that employment, and that you're actually part of that, too. But that was a very, very interesting takeaway from that Court of Appeal. And then lastly, the other one was Daniel, by the jury, was given, he was awarded, they found the employer liable, but only to 25%. 75% contributory negligence was found against Daniel, and for obvious reasons. I mean, Daniel climbed up the hoist and was engaging in this conduct at this coworker's egging him on to do it, and so he got tagged with 75% against him. But when it came down to punitive damages, the court said he gets 100% of his punitive damages. You don't reduce that by 75% of the contributory negligence against Daniel, but rather he keeps the entire 75,000, because the nature of the award is to punish as opposed to compensate, and nothing of Daniel's conduct actually was part of the misconduct that gave rise to the punitive damages. So another very interesting case where a plaintiff's damages were upheld by the Court of Appeal. So back to Jim Scarfone and Jacob Sazio, great work on that trial work, and their appeal counsel, Cynthia Cool, who did the appeal for them, or with them.
And would you say this is an emerging trend you're seeing, that the court is awarding and upholding these larger awards?
I do, but I also think it's more of a balance. Remember, juries are here. Juries are something that are very much being supported by the insurance industry. They like juries because they feel that in certain circumstances, juries have been very favorable to certain cases where the facts assist them, and that the juries actually have come back in certain plaintiff personal injury cases with zero verdicts. And when those zero verdicts had moved their way to the Court of Appeal, the Court of Appeal was reluctant to ever overturn them, saying that, hey, this doesn't shock our conscience. It's a zero verdict. Yes, you called evidence, but that was the jury result. And it's nice to see that when the plaintiff succeeds on having the markers move the other way, such as in the Moore decision from 150 to 250, the court has used the same rationale and said, hey, we're not going to interfere with those decisions. It doesn't shock our conscience, and that's what the jury found, and therefore we're not going to overturn it. So I think, if anything, I'm seeing a more balanced approach by the Court of Appeal. They're going to let those zero verdicts stand, but at the same time, they're not going to overturn these verdicts where, in that particular case, went up by 66%. So, yeah, I think it's more of a balanced approach by this Court of Appeal. I think it's good. I think it's right. And hopefully that will continue.
And is there anything else you feel you'd like to add?
Oh, the only other interesting one in the punitive damage case that I referenced was one thing came up was that the trial judge should have given a range of the punitive damages the jury was to consider. And the Court of Appeal said, no, the trial judge isn't to give a range unless there's agreement between counsel to do so. And I think that's an important element moving forward for anybody who is going to be doing jury trials in these types of cases. So I think that was an important thing that I should be noted as well.
Thank you, Patrick. That was very insightful. And that wraps up this episode. So thank you for watching.